You're watching the Urban Debater Mirror now. I'm Faye. Thank you for joining us. The Sabrimala temple disallows girls and women between the ages of 10 to 50 from entering the temple complex on grounds of menstruation and purity. Now, this has become a matter of legal debate since 2006, where the Kerala High Court in 1991 ruled that no outside authority has any jurisdiction to interfere with the decision of religious domination. And that judgment remained unchallenged for 15 years. In 2006, though, the matter reached the Supreme Court. The occasional hearing followed, and then in October 2017, the Supreme Court referred this matter to a 5-judge constitutional bench. Today, the court made some interesting and what can be deemed as progressive observations, and I quote, "On what basis can you deny entry? It is against the constitutional mandate. Once you open it to public, anybody can go. Your right to pray being a woman is equal to that of a man, and it is not dependent on the law to enable you to do that." End quote. The point is simply that Sabrimala is not a standalone case. There are many places of worship that restrict entry to menstruating women, calling them impure. But the Sabrimala temple case stands out because it doesn't have a blanket ban restricting entry of women the way the Haji Ali Dargah once did. And the Supreme Court today rightly asked, is menstruation a basis of age prescription? Does the notification leave out a 9-year-old girl or a 53-year-old woman who could be menstruating? The court also commented on the changing stance of the Kerala government. For our viewers who didn't know, in 2007, the LDF government supported women entering the temple. But in 2016, the UDF government declared that its restriction had been in place from time immemorial. It is part of the temple's unique idol concept. Today, the Kerala government once again came out in support of women entering the temple complex, and that's an important part of this entire story. The Supreme Court adjourned its hearing today and will continue to hear the matter tomorrow. And we await the Supreme Court's judgment, and our hope is that the court will set a precedent that aims to address the constitutional morality of India's social and political ideas. That this judgment is such that it liberates women's rights from a cluster of irrational religious ideas. We have hope, of course, in the Supreme Court. But the question that we need to ask today is this. We have a lot of religious concepts. Just yesterday, we were talking about triple talaq. A lot of religious concepts that fundamentally are anti-women and that deny rights to women. Our constitution says we're equal. So what comes first? The religious concept or our constitutional rights to equality? Joining me on the show right now, and I'm so pleased to introduce Indira Jaising, former Additional Solicitor General and a senior advocate with the Supreme Court who's been arguing this particular case. Ms. Jaising, first of all, good evening and thank you for giving us your time. I do understand in the middle of a matter like this, even 5 minutes of your time is a privilege, so I'm grateful for your time. I first want to, understand your arguments today before the Supreme Court so our viewers can understand which direction it's going in. Could you tell us what arguments you placed before the court today?
First, I'd like to tell you, since the case is still pending, I would not like to comment on the comments of the judges. For that, we have to wait for the judgment to come before rushing to any conclusions. But I can tell you what my approach to the case was, which I presented to the court. Now, I trace the historical issue of entry into temples, which was prohibited, for example, for Harijans. And I went on to say that this prohibition was done away with by the Constitution in Article 17 when they said untouchability should be abolished. Since then, a lot of temple entry laws have been challenged in the Supreme Court, but the Supreme Court has rejected all these challenges. And they have said all Hindus have an unconditional right to enter a Hindu temple, which is dedicated to the public. Now, drawing an analogy from this, I said to the court that women are identically situated with Harijans who were denied entry. And if the Constitution of India permits entry for Harijans into every single temple, how can that same constitution deny entry to every Hindu woman? So the issue here is whether a Hindu woman will be allowed entry for the purpose of worship. Let's be very clear. All that these women are saying is that we have a right to go inside and have a darshan, what is known in Hindu religion as a darshan of the deity, of the god, and pray in our own way. And my argument was that women have a right under Article 25 as much as anybody else to religion, and as part right to enter the temple and pray. And therefore, I said to the court that this too is a form of untouchability. The reason I said it is because I have noticed, and we all know it, that there is a lot of discrimination against women of the menstruating age, after puberty and up till menopause. I have seen within families, in our own homes, women are not allowed to enter the kitchen, they're not allowed to cook, they are considered untouchable. And not allowing a woman to enter a temple is a spillover of that same form of untouchability. And so I did say to the court that this is one of the modern forms of untouchability, which includes, for example, any form of social boycott. And this is a form of social boycott. And yes, I did argue that no religious denomination has a right to deny entry to any Hindu person into a temple dedicated for public use, only for the purpose of praying. And Sabrimala cannot be an exception to the rule.
Well, Ms. Jaising, I do respect the fact that you don't want to comment on the observations made by the court today. But I do want to ask you, in the larger scheme of things, when we talk about rights for women in India, what sort of an impact do you believe this case will have to women across the country who are watching right now? Women perhaps who would never enter, who would never travel to Kerala, to this particular temple. What is the larger impact?
Well, I would like to make a comment about larger impact. I would say that I'm very happy that this particular term of the Supreme Court, which began in July, appears to be dedicated to issues of gender. We began with 2 or 3 weeks of hearing on whether sexual orientation is prohibited by Article 15. We are going on to discuss whether Article 15 prevents all forms of discrimination against women, including entry into temples. And immediately after this case, we will be discussing whether adultery should continue to be a crime. Because the way it's structured, it treats women as objects, as belonging to the husband. And this is the reason why that provision has been challenged. So if you're talking about larger issues, I think this entire term of the Supreme Court, I believe right up to October, is going to be dedicated to issues of gender justice.
Ms. Jaising, with your permission, I would like to ask you a question that pertains to matters outside of the courts. There is also a lot of talk about the Women's Reservation Bill. The fact that it did pass through Rajya Sabha, it hasn't passed through Lok Sabha. In your opinion, how important is the Women's Reservation Bill to the rights of women across the country? Not just what happens inside of Parliament, but it's the ripple effect that it will carry to each and every one of us as Indian women.
Well, you know, let me tell you that there are several countries in the world that provide reservation for women in their elected assemblies. So it's not as if India is asking for anything very special. We also have reservation for women in all our panchayats. So we already have the trend set. And the reason for reservation, and let me also tell you that there are several countries in the world which provide reservation for women on their boards of directors. So the issue really is gender diversity in all institutions of governance. And I personally believe that without this kind of measure, namely affirmative action, namely reservation for women across the board, not only in Parliament, but even in other public and private sector institutions, we are not going to make much headway on the gender justice index in the world. A country like Rwanda has 60% of elected women, and they did it because they did provide for reservation for women in their elected assemblies. Today, it's a country which is held up as a model all over the world as having satisfied the gender justice index. So I do believe that we need reservation for women in Parliament.
And Ms. Jaising, of course, the arguments against that is that when it comes to justice for women, when it comes to prevention of crime against women, that women in Parliament might not be able to do much. Do you accept or do you disagree with that argument, that if we have more women rule makers or lawmakers, we'll have better laws for women?
Well, don't you think it's the same argument that we are hearing from the Sabrimala temple when they say that, it's gender stereotyping, basically, which is prohibited by the law, which is considered a form of discrimination. So the kind of arguments that you hear in objection to the issue of reservation for women is definitely a form of gender stereotyping, and we cannot accept it. On the question whether more women in Parliament will make for better laws, that is our hope, and that is the reason why we ask for more women. But I have to say, at this point of time, it's more a question of diversity in our representative institutions, because we also know that women often internalize this discrimination, and there can be situations in which women also do not necessarily vote or frame laws in favor of women. That is no reason for not saying we want gender diversity in our representative institutions. I must tell you, of course, that it is my belief, and I hope one day soon to see, that the Supreme Court also has 50% of all judges as women. I see no reason why there's just one or two women on the Supreme Court of India.
And the argument, Ms. Jaising, that would not be merit-based, and we would actually be forcing our way into these institutions. Do you buy that argument?
You see, this argument has been dealt with very extensively by a former judge, Justice P.V. Sawant, in his judgment in the Indira Jaising case. And he tells us very explicitly that so-called merit is nothing but a privilege, function of privilege, being born into privilege. Those who are born into privilege are born with merit, it seems. We all talk about dynasty. What does it mean? It means that you are born into privilege. It means that you are born with a silver spoon in your mouth and you have a head start over everybody else. So I don't buy the merit argument. I think merit comes from equality of opportunity, and equality of opportunity means affirmative action in favor of vulnerable sections of society. So no, sorry, I don't buy the merit argument at all.
Ms. Jaising, I know I have taken up a little more of your time than was initially agreed, so I thank you again for giving us your time this evening, and I wish you very good luck for the matter pending before the bench of the Supreme Court. And I do hope we can talk again when the court does give us its verdict on this matter and several others.
Thank you.
Indira Jaising on Mirror Now. Many thanks again for joining us, arguing there for the rights of women.
Thank you. Thank you for the opportunity.
And the equality of women.